May it please the court. Timothy Weber here on behalf of the Herreras. The Herreras bought an insurance policy from Tower Hill Insurance Company insuring their home. During the course of the policy, they made a complaint of property damage suspected due to Sinkhole. The insurance company hired an engineering company, apparently, Madrid Engineering Group, and they did an investigation. And as far as our record is concerned, the only evidence of that investigation is a copy of the report attached to an affidavit of Tower Hill's claims adjuster. We have no sworn evidence from Madrid Engineering Group as to the investigation they did, as to what they should have done or didn't do. We have no sworn evidence from the claims adjuster as to how he did or did not deal with that report when he received it. And more importantly, the Herreras were completely denied the opportunity to either question Madrid Engineering Group or the claims adjuster concerning any of the evidence in the case, or to receive any other discovery in the case before the trial court precipitously entered a summary judgment against them on a purely factual question. And that is that the Herreras somehow concealed evidence or facts and circumstances of this loss from Tower Hill Insurance Company. And they get there by claiming that the plaintiff's attorney's work product expert report must be disclosed before the Herreras could challenge a complete denial of their insurance claim in court. That is what Tower Hill convinced the lower court to enter summary judgment for. Under a provision in the policy that not giving an expert's opinion as to the cause of the damage is somehow concealing a fact or circumstance regarding the loss. The fact of the matter is the circumstances of this loss were undisputed. The ground underneath that house are the facts and circumstances. We may have 20 experts come in and evaluate and give an opinion as to what those facts and circumstances mean in the ultimate analysis, the ultimate factual question: what was the cause of loss to the Herreras home?
Under the insurance contract, there is a continuing duty to disclose so long as the insured intends to pursue the claim?
There is no such provision in this insurance contract, Your Honor. In fact, there's a very specific provision called your duties after loss. And they have never asserted in the trial court or here that the Herreras breached any provision of this insurance policy, let alone the your duties after loss. And that specific endorsement, Your Honor, specifically says you have to produce documents we request. There's no evidence in this record that anything was requested from the Herreras whatsoever. Now, they've made suggestions in some of their letters to the effect of, oh, well, we've always left the door open for you to come back and bring something else. Judge Kovakovich in the Cook case said such pleasant valedictions at the end of the letter are not a request for a specific piece of information. And so what we have here...
There's also an invitation to pursue neutral evaluation,
which is an optional procedure, Your Honor, and that was misrepresented.
Well, I understand it's optional, but it's just not, come back and see us someday.
I understand that, but the neutral evaluation statute says you can file suit or go to neutral evaluation, but their insurance policy says that. They also tried to mislead the trial court on that point, where specifically at page 137 of the record says, following receipt of a sinkhole report or denial of a sinkhole loss claim, you may participate in the alternative dispute resolution process. That is their sinkhole loss coverage endorsement in this policy. Yet they argued to the trial judge there was a mandatory condition precedent to bringing an action against them. And yet their own policy says you may. And that's because they're required by the statute to tell people that it's available. That is the only reason that's even in the endorsement. And so their argument that it's some kind of mandatory condition precedent to do that flies both in the face of their policy and the statute itself, which says it's an optional procedure. So then they make another series of arguments as to why no discovery in this case could possibly change the outcome of the case, even though there are conflicting expert reports as to whether Sinkhole was the cause of loss here. And they argue, well, as a matter of law, the failure to give your expert's report concerning the cause of loss must necessarily mean that you have forfeited all coverage under the policy. Not that you haven't yet established a breach of contract or there are conditions precedent to your right to recover. No, they have gone even farther in saying you've actually forfeited coverage. And the only cases they cite are cases where the insured comes in and willfully, affirmatively misrepresents the actual cause of the loss of damage. For instance, the Lopez case, where the girlfriend calls up and says, I was driving the car and I ran off the road, where the insured, the man, was driving the car on a racetrack that was specifically prohibited. And in those cases, we're talking about making a material misrepresentation or concealing a material fact to get something that isn't otherwise covered under the policy. The insured is trying to gain something that isn't covered under the policy. And here, if it's a sinkhole, it's covered under this policy. And again, the facts we discover to prove that their engineering report is incorrect can occur at any time. It can occur during the litigation. They occur in depositions that would occur in the normal course of discovery in a lawsuit. They occur in the experts I hire, either consulting experts, which are my work product, or testifying experts I decide to designate for trial. But again, they've made the claim that they have an irrebuttable presumption that you can never refute, you can never contest. The trial judge asked them point blank, are you saying you can never be sued for breach of contract? And he said, yes. Yet the Supreme Court in Warfel says such a presumption would be unconstitutional. And this court's own opinion in Colella says, we agree that does not insulate the insurance company from liability for breach of contract that you complied with the statutory report. That is what this court said in Colella. And there it was just reversing a judgment finding the insured was entitled to win as a matter of law and remanding, saying there are factual questions concerning whether or not the insurance company breached the contract. Here, they want to cite Colella, saying that there could be no factual question as to whether the insured breached the contract, which is directly contrary to this court's holding. But more importantly, the Supreme Court in Warfel tells us exactly what this presumption of this report is about. This is a statute that was started out in 1992 with the legislature trying to protect the public from bad insurance companies' claims handling practices. And it set a minimum standard of care. Before you deny a sinkhole claim, you must do these minimum things. It was not to insulate insurance companies from liability. Yet they argue extensively in the trial court and extensively here that compliance with the statute insulates them from liability for the coverage they agreed to provide. When in fact Warfel only describes this is to protect the engineer who does the report from tort-like claims for title defects and the insurance company from tort-like claims for the way in which they handle the claim. And so I would submit Herrera's bought coverage. If they have coverage, they're entitled to present that case. Whether they presented all their theories and opinions and work product and all the facts they had gathered after their claim was completely denied, they're entitled to have a trial on that. And I think that's the real problem in this case, is the insurance company made the claim that, well, you could only consider evidence that was brought to our attention before a suit was filed. Where has that ever existed in any breach of contract claim ever? If you make a complete denial of coverage, that's enough. The claims process is over. The insured has only one choice. Well, they have two. They have an optional choice to go to neutral evaluation. But their other choice is to file a lawsuit. And the Herreras did nothing wrong here. They did the responsible thing, which was to get a second opinion confirming their beliefs before they filed suit. And they've been punished for it. And so here we had a rush to summary judgment, a complete denial of discovery, and this is not a situation where the Herreras have been dilatory in pursuing discovery. They served discovery with the initial complaint. Tower Hill flatly refused to answer any of it. Tower Hill files a single affidavit from a single affiant in support of their motions for summary judgment. The Herreras twice asked to depose that affiant, just to even see if his affidavit, he even has knowledge of the facts in the affidavit. And they flatly refused to allow that. And they argue in front of this court, oh, of course he had personal knowledge of what Madrid did. He's a corporate officer. Well, there's no way to test that without his deposition. And so the Herreras filed a motion to compel the deposition of the only affiant at the summary judgment hearing, and the trial court refused to allow that discovery and granted summary judgment against them without any ability to question either the underlying facts of that affidavit or the underlying investigation by Madrid. And I think what's so clearly erroneous about this is that on its face the affidavit is from a claims adjuster at the insurance company. It is not the engineer who did the study. They want you to believe that they're even entitled to this presumption. Yet there's no evidence in the record that they meet the criteria for the presumption. In fact, the report attached to the affidavit on its face doesn't have a proper certification. It says, to the best of my knowledge and belief, we have done sufficient testing to rule out Sinkhole as the cause of damage. Not even this is my professional opinion and I'm an engineer. To the best of my knowledge, information, and belief, we have done enough to rule out Sinkhole. And so it's on the basis of a hearsay report attached to the claims adjuster's affidavit, and neither the claims adjuster can be deposed or the engineer who provides the report. And the trial court says, I am affirmatively finding you concealed material facts from Tower Hill. Now, there's no evidence that the Herreras even had their expert report before this suit is filed. There's no evidence that any decision from anybody was intentionally made not to give them something that they were entitled to, or that someone was trying to gain something that they wouldn't otherwise be entitled to. And in fact, there's no indication from any of the sworn testimony that it was even material to Tower Hill's decision. In fact, the record speaks volumes otherwise. Tower Hill argued at the summary judgment hearing that it's irrelevant what that report says. We rely on our guy because he's presumed correct. Furthermore, given the report, do you see any evidence they paid the claim? None whatsoever. We're still here, we haven't been paid. And so the indication that this is somehow material to their investigation, when they ignore the report when they get it, and argue at the summary judgment hearing that it's totally irrelevant, yet the trial judge is going to resolve all inferences against the Herreras in this case on an incomplete record, on a series of legal theories that are both contrary to the Supreme Court's opinion in Warfel, contrary to this Court's opinion in Colella, and contrary to basic breach of contract law that says whether the defendant intentionally breached a contract is totally irrelevant. And other courts have addressed this. Judge Kovakovich and Judge Meriday in the Middle District have both had this precise issue. And they both specifically said, this presumption doesn't insulate you from breach of contract liability, nor is there any duty or obligation to furnish the report before suit. And they cannot point you in this record, in any statute, or in any decided case that predates today, an affirmative obligation on the part of the Herreras to turn over their expert opinion as to the cause of damage before filing suit. They're not going to find it in the insurance policy. They can't quote a provision of this policy that requires it. They can't quote a statute that requires it. They want you to believe that if everyone had just been holding hands and singing Kumbaya before filing suit, that they would have behaved differently. They want you to take it on faith that if we'd have gotten the report, we would have paid, or we would have at least done neutral evaluation. Then if we lost, we would have paid. Just trust us. All these other things would have happened if the Herreras had just given us their contrary report. Yet they get it within 30-some days after suit is filed. And they still never changed their behavior. They still haven't paid. They didn't pursue neutral evaluation. They filed 4 motions for summary judgment declaring we should win because we have an expert report that's presumed correct. And I would submit that is the exact type of unconstitutional presumption. The Warfel case finds, also the 2 Middle District judges noted that it would be unconstitutional to give that kind of an effect to the presumption. And this court should likewise, and this court has already said in Colella, does not insulate the breach of contract claim. It's for the bad faith suit, this presumption. That's all it is. It's a minimum standard of liability for the adjuster before they deny a claim, and it was done, according to the Supreme Court, to curb abuses in the insurance industry. And they want you to construe that as this was intended to protect insurance companies. Warfel specifically says this was not intended to protect insurance companies. This was intended to protect insureds.
Mr. Weber, you're down to 5 minutes. You didn't tell me how much rebuttal.
I'm going to reserve about 3 minutes, Your Honor. I'm going to hit one more point here. They've argued in their Tipsy Coachman argument that no payment was due and therefore there was no claim. They cite a loss payment provision, but they leave off several parts of that. One of which is sort of a silly argument. You can't, there's no obligation for us to pay before a judgment is entered against us, so you can't get a judgment against us. That is the argument they made on that motion. And then they missed, though, at page 122 of the record, an endorsement to the policy that changes the loss payment provision to specifically say, loss will be payable within 90 days of receiving notice of a property insurance claim. We will pay or deny such claims or portions thereof unless there are factors beyond our control that would reasonably prevent payment. And so here's the steps they missed in the policy. When they make a decision to deny a claim, there is no proof of loss and then loss payment within so many days after a proof of loss. Once they denied the claim, the insured doesn't have an obligation to submit a proof of loss or to do the procedures that they have following that. It's a denial. It's a complete, go home, you're not covered, this policy doesn't cover you. And in fact, their policy says, you don't submit a proof of loss till we ask for one. And so their argument that, well, payment's only due 20 days after we receive a proof of loss, that assumes that they haven't done something to discharge the insured's obligation to comply with that. They never requested a proof of loss because they completely denied the claim. And their policy says payment is due within 90 days of receiving the claim. We either pay it or we deny it. And that's what their policy says. And so I respectfully submit there's no presumption that protects them. The loss payment provision doesn't protect them. The neutral evaluation statute is clearly optional under both the policy and the statute. And concealment was just not conclusively established by the evidentiary submission they had, notwithstanding the complete abuse of discretion in denying the Herrera's all discovery before this judgment was entered. And I would ask this court to reverse the summary judgment and remand for further proceedings. Thank you.
May it please the court, Carol Rooney for the appellee Tower Hill. A rush to summary judgment, the same day the Herreras got their expert report, they filed their complaint. My client did nothing wrong here. As the court knows, Florida has a whole statutory scheme that governs how sinkhole claims are to be handled. And it actually provides that when a sinkhole claim is received from the insurance company goes out and does an inspection, and they're mandated to hire a professional engineer. And that's exactly what they did here. They hired Madrid Engineering, who went out and conducted whatever tests that Madrid Engineering alone determines are necessary to determine the absence or existence of damages caused by a sinkhole. And that's completely under the statute, Madrid Engineering's call. So Tower Hill did that. They got a 61-page report from Madrid Engineering that's certified to the best of Madrid Engineering's engineering skill that there were no damages caused by a sinkhole. They wrote to the Herrera's attorney, because that's the first contact they ever had was through the Herrera's attorney. And actually, prior to retaining Madrid Engineering, they notified the Herrera's attorney that that's who they were going to be retaining. Never got any objection, oh, you can't hire Madrid Engineering. They went ahead, hired Madrid. So they get the 61-page report, as they're required to do under the statute, and that's all they're required to do is to get this report. It's certified by Madrid Engineering. They provide it to the Herrera's. They explain in their letter that we cannot provide coverage based on this report. And even in the letter, they say if further testing is required or demanded, please let us know. We reserve our right to continue our investigation to determine the absence or existence of damages caused by a sinkhole. They hear nothing, no response for 5 months. counsel points out that they have to deny the claim, accept or deny it within 90 days. Well, 5 months go by, they hear nothing. The next thing they hear from the Herreras is a demand for payment pursuant to a complaint filed in the circuit court saying, you, Tower Hill, have breached your contract. We are entitled to repairs for damages caused by a sinkhole. They're hauled into court under a breach of contract. Tellingly, that complaint doesn't make any mention whatsoever of any adverse report or additional test results. It's not even mentioned. So their sole basis for recovery under their breach of contract cause of action against Tower Hill is, Tower Hill, we're entitled to repairs for damages caused by a sinkhole. Well, then let's go back to the Florida statutes. So Tower Hill sees, here's this complaint. Well, we have this engineering report. That's all we have in our claim file. That's what we're required to do under the Florida statutes. So they respond with a motion for summary judgment.
Why didn't they respond with a discovery request for the basis for the assertion in the complaint?
Because, Your Honor,
What I'm wondering here is I've seen a number of these Tower Hill cases come up.
yes.
And the 4 motions for summary judgment that always seem to get filed. And I'm struggling with how you get a forfeiture of coverage here, because I don't see how you were injured.
Well, Your Honor, keep in mind, too, there's 4 motions for summary judgment. The only one that really concerns forfeiture is the concealment one. But let's just talk about initially what
But
first...
I thought that's the part that's what you're talking about now, correct?
I'm talking, yes, we're entitled to summary judgment under all 4 of those motions, including but not limited to the one on concealment. But even if this
Now,
court...
how was it concealed?
It was concealed because they have an obligation. Here's the policy.
You have denied the claim.
We denied the claim with the reservations of rights to continue our
Denied the
investigation.
claim. You didn't honor it within 90 days. You denied it, correct?
Correct.
They
Correct.
go, they get a second opinion. It's
Correct.
different from yours. And you're
Correct.
saying they have an obligation to go back to you as opposed to filing a lawsuit that says, we have sinkhole damage, you have a contractual obligation to fix it, and you have not done that. That somehow you were damaged to the point, because they didn't come to you first before filing that suit, that you were damaged to the point that that's a forfeiture of benefits.
Your Honor, because it falls within the concealment provision, because there's, without question, it's material. Without question, they deliberately did not provide it. That's not even a dispute.
Go back.
You didn't ask for it, did you? You haven't made a discovery request here. The first thing you come back with is a motion for summary judgment.
Their affirmative obligation falls under the fact that just the plain language of the concealment clause, which has been, this same language has been upheld in other courts.
Remind us what it says.
It says, under Section 1, property coverages, with respect to all insureds covered under this policy, we provide no coverage for loss under Section 1 property coverages, whether before or after a loss, one or more insureds have intentionally concealed any material fact or circumstance related to this insurance.
That's
I don't
material
know,
fact or circumstance.
I don't know
that
what-
includes an expert opinion about what caused it.
Your Honor, I don't know what could be more material to a sinkhole claim, and in fact, they've admitted materiality because they filed it in opposition to a motion for summary
They always
judgment.
maintained it was a sinkhole, correct? How did they didn't conceal that?
Your
I
Honor,
mean, what fact or circumstance related to the claim did they conceal? All you're saying is that they didn't volunteer to you before they filed the lawsuit, that they had an expert opinion that this was a sinkhole. Which expert opinion was consistent with the fact or circumstance they have asserted to you from day one?
Your Honor, it's evidence of a dispute, and we have a contractual and statutory right, when we're alerted to evidence of a dispute, to pursue an alternative to litigation to resolve that dispute.
When does no
That's
mean-
where the obligation comes in.
When does no not mean no? You deny the claim. You know, it seems to me at that point all bets are off. You deny the claim, and if they want to pursue litigation, they're free to do that, and they get their second opinion.
Because sinkhole claims are different, Your Honor, because the Florida legislature actually gives the insurance company the right, if they
Yeah,
do
but
A, B, C, and D, to deny
right.
it.
And so did you, I mean, where is the obligation then, at that point, you know, you can say, we reserve the right for further investigation, and is that forever?
That to the
If they find something different, you know, a year later, you know, you say, oh, you didn't show that to us.
to the extent
You
that
you
they,
lose your coverage.
Your Honor, to the extent that they were going to demand payment from their
File a
carrier,
lawsuit.
Your Honor, that's a written demand for payment, and that because they filed that written demand for payment.
I mean, is that how you were harmed by this concealment?
The prejudice is presumed to be because we've now been deprived of our right to have this dispute determined outside of the courtroom. I mean, neutral valuation is defined under the Florida Sinkhole statutes as an ADR. It's an alternative to litigation. It's well settled that ADR is highly valued under Florida law, and here we had a right. It's not mandatory, but certainly we have the right to try and resolve these claims outside of litigation, outside the umbrella of the courthouse. And we were deprived of that right.
Was there a way to invoke that ADR method within the context of a pending lawsuit?
But, Your Honor, then we'd be doing it under the umbrella of the lawsuit. We'd still be in litigation. At best, what you would do is just stay. But
Okay.
at that point, it's like our right to have litigation completely out of the picture was destroyed. At a minimum, we were entitled to be alerted to evidence of a dispute. And that's what that expert report is, and that's why sinkhole cases are different. But I also want to turn to some of the other, we have our concealment motion for summary judgment. Without question, that was correct, but we also have...
To something Judge Northcutt said, I'm trying to see how far your position goes. What is the end point? If they wait a year to sue, is your position the same? If they file suit anytime right up to the last day of a statute of limitations, your position, if they had that report, your position is no coverage.
Your Honor, our position would be that I think that's where it's getting confused. We're not saying we're immunized from a lawsuit, but what we're saying is we defended the lawsuit that was filed, and the lawsuit that was filed is based on an improper denial of the claim. But if it's undisputed that all we had in evaluating our claim is an engineering report that we obtained pursuant to the Florida statutes that says that there's no damages caused by a sinkhole, how could we be in breach of contract?
Their expert.
And can't the complaint be, our house was damaged by a sinkhole. The insurance company has a contractual obligation to repair, and it did not. That's the complaint. Not that it improperly denied, not that you didn't do what you were entitled to do by, you know, hiring an engineer and so forth. But as a matter of fact, we have a sinkhole, and as a matter of contract, the insurance company is required to repair.
And even under that complaint, we're still entitled to summary judgment, Your Honor, because Florida legislature has determined that the only repairs that are covered under the contract are those recommended by the engineer hired by the insurance company, the independent engineer. And it's undisputed that that engineer determined not only are there no repairs required to the property, but there are no damages caused by a sinkhole. So how could the insurance company be in breach of contract? There simply is no evidence. We met our burden on summary judgment under that complaint that's pled that says we're entitled to payment for the repairs for damages caused by a sinkhole. Based on the undisputed material facts, we could not be in breach of contract. We're defending just against the complaint that's filed. And I also want to point out, too, counsel was talking about all the different ways that this could have handled. The reason that we're here today, and Your Honor has noted that we have a forfeiture. They set this path in motion. There were many ways and alternatives that they could have pursued this.
Regardless, I'm trying to figure out how you were so harmed that you were entitled to exact a forfeiture of coverage. Isn't that what the standard is, regardless of what the policy says?
Your Honor,
the case law says?
The case law says that prejudice is presumed when you have concealment established as a matter of law, and that's what we have here. But even
so, you're telling me when I ask you how you were harmed, all you can say is that it was presumed?
No, we were harmed not because we are in litigation and we have the specter of a confession of judgment. We don't have the
specter. So your feelings were hurt.
No, we also have a civil remedy notice, Your Honor.
Right, you're telling me.
No, we also have a civil remedy notice that was filed that we now have potential liability for bad faith, and we'll never be able to resolve this case outside the umbrella of the courthouse, and that's what that ADR provision is for. So we've been denied that. We have been
So
harmed.
you couldn't file, elected neutral evaluation or file a motion for a stay for the neutral evaluation in the court.
Then we're still in litigation. So,
Grants the stay, you do the neutral evaluation, and you follow this procedure.
Your Honor, we're not required to do that. When we're sued for breach of contract, we're entitled to defend the suit that was filed. And we did defend the suit that was filed, and we established as a matter of law that we were entitled to summary judgment. And even taking the concealment motion aside, even if you disagree and say that goes too far, we weren't entitled to that, we had 3 other motions for summary judgment that established without question that there could be no breach of contract as a matter of law. And this is how the Florida legislature has decided that these claims will be handled. Under the statute, it says that that engineer, his recommendations as to repairs carry the day. If his recommendations as to the repairs carry the day, clearly they must carry the day to causation. And for all practical purposes, the only way for a policyholder, if they get that kind of report, to challenge it is to go through the neutral evaluation process. And then if they disagree, then you file suit. But we're just defending the complaint that was filed. And that breach of contract complaint alleged that they're entitled to payment for repairs. We're entitled to summary judgment on that complaint.
But under your argument, what is an optional ADR method becomes mandatory for the insured if they're dissatisfied with your engineer's report.
They can still file suit, Your Honor, but they don't get a free pass to a breach of contract. They're still going to have to plead and prove a breach of contract, and that's where they're simply unable to do it under the complaint that was pled. And as this court noted in Colella, court can envision maybe there might be some circumstance or fact pattern where you can establish a breach of contract in a sinkhole case, but you can't do it in this case. I'm not saying that they can't file suit. Certainly, they have a constitutional right to file suit, and we have a constitutional right to defend ourselves, and that's exactly what we did. And just to address
Answer one more question on the
Sure.
concealment. The report was in hand before they filed suit, correct?
The report was dated the same day the complaint was filed.
Suppose they had filed a lawsuit for breach of contract or whatever, and the lawyer subsequently obtained a contrary engineer's report. What's your position on how that operates as a concealment?
Our motion for summary judgment on concealment was based on the fact that they're suing us for not paying their claim at the same time that they have an engineering report that they knew was never considered in our evaluation of the complaint. They know it's material, and they deliberately decided to send a written demand for payment and not provide it. So it's not so much the lawsuit, it's the fact that we're sending you a demand, you owe us money, and they have this material information that's pertinent to that loss, pertinent to the insurance, and they deliberately decided not to provide it. That's the concealment.
If I hear Mr. Weber right, you didn't do anything differently. I don't hear or see that, well, there was further review of the loss. You just move forward, litigate.
I think what he's trying to make it seem like the engineering report is just its work product. But what is it probative of? It's probative of whether or not we breached the contract, correct? And that's where we go back to the discovery issues, and he's complaining, and again, all discovery is waived. There is absolutely no basis to reverse on failure to take discovery because the trial court did not enter one order or ruling on discovery. So discovery is definitely not a basis that it should even be considered by this court. That has been waived completely. Anything related to the sufficiency of the affidavits has been waived. Never a motion to strike, never a ruling on any discovery issues, period. We're limited to just final judgment for summary judgment. But just even getting back to how he's arguing, this is just work product, it's a second opinion. No, it's the fact that they had this material information, and it's undisputed that we didn't have it. It's what we had in our claim file and what they had and when they had it. It's not the contents of the report, because again, the insurance company, under Florida law, has no contractual or statutory obligation to verify the sufficiency of any of these engineering reports. We're not required to go and hire another engineer to come back and do a second look. The statute specifically says that the tests that are conducted by the professional engineer are solely determined according to their professional opinion. They have complete 100% discretion. So under our contract, how could we ever be in breach of contract according to what they decide to do? We can't. The only obligation we have under the statutes and our contract is to hire the engineer and to get the report. And once we've done that, the statute is explicit. It says you may deny the claim if you get this report. And so how could we ever, put the concealment motion aside for a moment, how could we ever be in breach of contract under the complaint that was pled and based on those undisputed material facts? We simply can't. And on that basis alone, the summary judgment should be affirmed. Unless the court has any other questions for me, I would respectfully request that based on the undisputed material facts, the clearly established record, and Florida law, that you affirm the final judgment that was granted to Tower Hill.
Thank you.
Please, the court. The impossible breach argument has again surfaced its head in this court. They want you to believe that there is no way Tower Hill can ever breach this insurance policy. All denials are non-final. You just keep bringing us more information, and we say, well, that's not good enough yet. Furthermore, whatever our engineer says, that's conclusive. Well, that's directly contrary to the Florida Supreme Court's Werfel opinion that says such a conclusive presumption would be unconstitutional. In fact, they say no such value is even given to that opinion. And I would ask the court to read Werfel. They believe that the fact that they promised to provide coverage and didn't provide it is not a breach of contract. And that is not the law, and that is not anywhere found in any of the statutes upon which they relied. In fact, the Florida Supreme Court says, if anything, the presumption of correctness attached to the report appears to be aimed at shielding the engineer or professional geologist from liability for title defects and the insurance companies from claims of improper denials of claims. Supreme Court in Werfel remanded for a trial for the insured to prove that there was a sinkhole there. What they're saying is you don't get to file that subsequent bad faith suit by the way they handled the claim. And that's all this presumption ever was intended to do. And the Supreme Court goes through the history of that statute and clearly outlines that. Werfel, they remand for a new trial for the insured to prove. Same facts as this case. The insurance company gets an opinion, they send a denial letter, insured files suit. That's the fact of Werfel. Also the facts of Colella. With this court, sent it back for a trial on whether the insurance company breached the contract. They want you to have an irrebuttable presumption and say they can never be proven wrong. And their statute they cite doesn't say that. It says the plan for remediation of the engineer who confirms sinkhole activity is the one we follow. Well, their engineer never confirmed sinkhole activity. Ours did. And it would be ridiculous to say that we have to follow the remediation plan of the engineer who says there's no sinkhole there when the statute says we follow the recommendations of the engineer who confirms sinkhole activity at the site. It doesn't say the insurer's engineer, it doesn't say anything but that, both in the policy and in the statute. Yet they have turned that into whatever our engineer says goes. We can never be in breach, you can never sue us. There's no process or mechanism for you to ever get the coverage that we agreed to provide you. Our contract is illusory. And that's what they are telling this court, that's what they told the trial court, and that's what these flurry of summary judgment motions are all about. And to suggest that discovery is waived, the only affiant at summary judgment, we have a motion to compel his deposition scheduled for the same day. Trial judge refuses to allow it and enters a final judgment. I don't know how that's a waiver under any stretch of the imagination. And the transcript of the summary judgment hearing at pages 25 to 27 clearly shows trial counsel's objection to the affidavit, that the lack of personal knowledge of this affiant concerning the facts upon which he's testifying to. That is preserved.
Mr. Weber, your time's up.
Thank you very much, Your Honor.
Thank you both. The court will be in recess for 15 minutes.